The next issue is the question of when in a third-party funded case, the extent to which that gives rise to competing interests between the client and the lawyer and the funder. For example, when to settle a case, who actually is going to take the key decisions. Gavin, if I could turn to you first, just from a sort of practitioner's point of view, do you see it as a problem or?
Well, I think there's potential for conflict in any litigation case, but I don't think the problems are insuperable. I think we should bear in mind that most of the time there will be a common interest between the client and the lawyer and the funder, if there's one involved, to win the case and to recover as much as possible. There can, of course, be circumstances in the case where there is tension between the lawyer's interest and the client's interest and the funder's interest, and that needs to be dealt with. But I think we should also bear in mind that that can happen in litigation which is funded under the traditional model entirely by the client, with the lawyer working on hourly rates, because that type of arrangement will tend to reward a lawyer who works slowly and does as much work as possible, whether or not that's strictly necessary for the case, and it will pay the lawyer to run the case all the way to trial. And yet we know that in most situations that doesn't happen. I think we can all think of cases we've been involved in where we would suspect that of the other side, but generally speaking that's not been a problem. I think with regard to third-party funding, that the potential conflict can be regulated first of all by the lawyer's professional obligations to act in the client's best interest and to advise them properly. Secondly, I think the contract between the funder and the client can deal with these kind of situations and make it clear who takes the decision and what the consequences are of any particular decision and whether the funder can pull out and so on. And so I think that's the way it can be done. I think the other thing is, if it's a high-value case and there is doubt and the client wants a second opinion, they can get that from an independent solicitor. But that can't realistically be done in very low-value cases because the cost wouldn't justify it.
Thank you. Kerry, again, from a practitioner's point of view, do you agree with that?
I agree entirely. The problem is that post-October the 6th, as lawyers, we deal with conflict. That's what we deal with. You can't avoid it. You spot it and deal with it. And ultimately, you are prevented from earning your living because you're struck off if you behave wrongly. That's what we all grew up with. And the problem here, and it's not essentially a third-party funding problem, but the problem with all of these other issues, including third-party funding and insurance, is that if you deregulate the legal profession, and that's what's happening on the 6th of October, then it won't necessarily be lawyers dealing with these matters without criticising them. The fact is that you or I will be mortified to get a letter sitting on our desk complaining that we've not acted in the best interest of our client. That's what we do. That's what we're bred to do. A supermarket or a bank or insurance company won't give a toss. It's just part of running a business. And that's why no country on earth has deregulated the legal profession, ever. And you may think, what's this got to do with third-party funding? It's got a huge amount to do with it, because in a time when legal aid's being abolished, when banks have gone on strike, what you do need is innovative methods of funding and working, no doubt about that. But I believe that what you need in combination with that is a strictly regulated legal profession that we have, with all the values that we're brought up on and taught quite rightly. And my worry is, I have, as I keep saying, I'm in favour of third-party funding. My worry is that they've been called grubby and rogue, but you'll get rogue and grubby third-party funders in bed with rogue and grubby providers of legal services, and the public, even actually some of the sophisticated business public, simply won't be able to tell the difference.
Susan, just turning to the sort of funding perspective, it always slightly mystifies me. There's this issue about you have no control, and yet you have a very clear interest in how the case is run and what decisions are taken when, etc., etc. So how does that work in practice?
Well, for us, one of the important things to try and avoid any subsequent conflict is to make sure that we understand the dynamic between us, the claimant and the lawyers up front. And that's the best way for us to try and understand that relationship. And on occasion, we have chosen not to fund a case because we think that dynamic doesn't work. It's very important that we think we're going to have a good relationship when the case is ongoing, because litigation has problems and challenges and there's unhappiness along the way. And most of the claimants that we fund only litigate perhaps once in their lives. So there's an unfamiliar process they're embarking on. I mean, it is without question the point, isn't it, that we're paying the costs for this case, and we're very interested in how it's going to be run. So as well as wanting to understand the budget, we want to understand the strategy for the case. But the fact of the matter is that we do only retain the right to withdraw if the case has materially adversely declined. So defendant's gone bust, merits have gone through the floor, value has gone through the floor. We invest hundreds of thousands, sometimes millions of pounds in cases. It simply isn't in our interests to walk away from things. And actually what we have found is that the client likes having us alongside. We're an additional sounding board for the way in which the case is being run. And I really can't recall much at all conflict having arisen, because we've tried to be careful that we've got that relationship sorted up front. But yes, we've got to retain the right to withdraw from a case. It would be bonkers to think that we turn up at court with a dreadful case saying, well, because we were told we had to. That's not in anybody's interests to do so. So I think, again, I think people fret about the withdrawal, they fret about conflict. Actually, it can be very well managed because, as Kerry is saying, as Gavin is saying, you're used to managing that. You're used to the problems that arise. And we bring all that to bear, and we're experienced litigators ourselves. We bring that to bear into this relationship and make sure that it works, because we want a good outcome.
Is that your experience, Neil?
That's right, and we've never seen an issue in practice of a conflict becoming a problem. The answer is we do deal with it up front. It's in the how we relate to the claimant, what we're entitled to, what we're not entitled to, who has control is all set out in detail in the funding agreement, so everyone's clear about that. And as Susan says, our interest is most closely aligned with that of the claimant. We don't charge any fees. We only get our money back at the end of the case if it's successful, and we only get a return out of the damages. If the claimant doesn't recover, we don't get anything either. So of everybody involved in the litigation, we're the one who's got the least conflict with the client. And one of the attractions of funding is, particularly if solicitors aren't working on a CFA, it brings the solicitor back into the role of simply providing the best advice on the case. The funder receives it, the client receives it, we all move forward. It's not a problem that we've seen in practice at all.
I think I'd add to that in our research we're not seeing any of the things that are concerns in America about funders wishing to be involved in the running of a case. I think what both Neil and Susan have outlined is that isn't the case. That isn't the case in if we say the pure funding model that we have in the UK at the moment. Because funders are partly investing in the quality of the case and the quality of the legal team, and trying to preserve the lawyer acting in the best interests of the client. So the confidence in the lawyer is quite important in taking a decision as to whether or not to fund. So there isn't that need for the funder to become involved in actually running a case or trying to work out how the case is managed. We may come on to this in a little bit more detail when we talk about one of the things we can learn from America, because I think that is one of the things we can learn from the US system.
Fine, we'll come on to that in due course, yeah. Malcolm, anything to add on that?
I think there is a great opportunity for conflict between the three roles of claimant, sort of lawyer and funder, and particularly at the time of formulating the contracts. And I would always advise my potential clients to go and actually pay a lawyer. I mean, that might sort of break some people's heart, but pay a lawyer for some early advice on these particular contracts before you sign them. Because they are
an independent lawyer, if the lawyer's going to run the case.
Completely independent, because they are complex and difficult to understand. If you are only litigating for the first time, both a CFA and a funding agreement are quite daunting instruments. But I think by the same token, it's not unreasonable for a litigation funder, for example, and a CFA lawyer to protect themselves against the claimant who wants his day in court at somebody else's expense. And that's the other side of the equation as well. So there are various issues that have to be balanced out here. But once the contracts are signed, then I agree, everyone's on the same team and interests are aligned. But it's getting to that stage that's important.
And John, does your research chime with that? Or?
Well, I mean, I was just thinking, I mean, from the client perspective, it's, talking about conflict and having an understanding of the nature of the agreement. We kind of ask a lot of clients, it seems to me. I mean, conditional fees, the fact clients, well, I suppose it's debatable if they do understand conditional fees, but third-party funding actually seems kind of an obvious structure and an obvious kind of agreement. in a way. I mean, the dangers are there in terms of conflict, but I think it's conceptually quite easy to explain to people.
And I think as well, one of the things that we found in our research is that a number of the funders who are currently operating in the UK actually want to meet the client as well.
Right.
So they want to make, I'm sure that's both of your experience.
Every time.
So they want to, I don't sound like I'm selling Neil's business now. So they actually want to meet the client. So the client is aware of who the funder is, and that there is a clear transparency there. The funder understands what they're getting into, and the lawyer is properly able to advise the client on the nature of the agreement because of that meeting and because of that direct contact with the funder.
I'm sure it works the other way around as well. You know, the client wants to meet the funder.